Today I'm going to talk about restraining orders in the state of New Jersey. Specifically, I'm going to talk about what the plaintiff needs to show in order for the court to grant a restraining order. Now, it's really important to note that there are two types of restraining orders in the state of New Jersey. The first is a temporary restraining order, and the second is a final restraining order. A temporary restraining order is just that. It's a restraining order that's temporarily put in place until the plaintiff, which is the person who files a restraining order, obtains a final restraining order. How does one obtain a final restraining order? Well, it happens through a trial. So what happens when somebody obtains a temporary restraining order? Typically, the complaining party, which is typically the plaintiff, will go down to the police station, will find an officer, and they'll submit a statement explaining what happened. The officer will then determine whether or not this appears to be a domestic violence issue. It'll have to go in front of a judge. More often than not, the officer will call the judge in the municipality of the town where the party is located, and the judge will take testimony from the plaintiff, which is the complaining party, concerning the situation, and the judge will more likely than not grant a temporary restraining order. Once that temporary restraining order is granted, it'll be served upon the defendant. That's the person that the restraining order is against, and the court will set a court date. Now, that court date is essentially the date where the complaining party is looking to obtain a final restraining order. In order to obtain a temporary restraining order, there's typically something called a predicate act. The predicate act is typically the act that caused the person to go to the police station to request a temporary restraining order. There's another way to do it, and that's if the parties are in a situation of domestic violence and officers show up to the home. Typically, the person who committed the act is usually arrested. The person who is the victim in that domestic violence situation will be advised of their right to obtain a temporary restraining order, and at that point in time, if the person wishes to move forward with a temporary restraining order, the officer will contact a municipal court judge who will typically enter that temporary restraining order based off the testimony given by the victim at that time. Now, a lot of my clients wonder what's going to happen at a final restraining order hearing. This is essentially a bench trial. What's important to remember is that a final restraining order requires the burden of a civil matter, and that's preponderance of the evidence. It's not a criminal matter per se. It's considered typically a quasi-criminal matter, meaning that there are criminal implications, but the standard is much lower. The standard for a criminal matter is beyond a reasonable doubt. The standard for a civil matter is preponderance of evidence. I'll use an example. Jane Smith files a restraining order against John Smith. Jane Smith is the complaining witness. John Smith is the person who is labeled as the defendant. Jane Smith would have to submit evidence to the court to show that an act of domestic violence occurred. The judge would have to determine whether or not it is more likely than not that that act of domestic violence actually occurred. In a criminal matter, the state has to prove that that act happened beyond a reasonable doubt. It's a totally different threshold. It's a much easier burden for the plaintiff to prove in obtaining a final restraining order. When talking about obtaining a final restraining order, it's important to know what the court looks for in granting these final restraining orders. In order for the court to enter a final restraining order, they must determine three separate things. These three things are pursuant to a case called Silver v. Silver. The first thing the court needs to determine whether or not the parties had a particular relationship with one another. What does that mean? In most situations, the parties are either boyfriend and girlfriend, husband and wife. In some situations, they're actually roommates. In New Jersey, the courts have ruled that roommates also count as parties in a relationship. The second prong that the court needs to determine is that the alleged predicate act was actually done by the defendant. So, what are some predicate acts? Harassment, assault, simple assault, terroristic threats. Those are typical predicate acts. There's a laundry list of them. But in my experience, an overwhelming number of domestic violence cases typically boil down to two predicate acts: harassment and assault. One of the most common grounds to get a restraining order in New Jersey is harassment. Harassment is shown when someone communicates to another person in offensively coerced language, or at extremely inconvenient hours with the purpose to harass another, or commits an offense touching, such as kicking or shoving, with the intent to harass, or engages in any other alarming or seriously annoying conduct. As you can see, that's an incredibly broad definition of harassment. I bet you're thinking right now, I've done things that fit into that category. Wow, that can be categorized as harassment? Sure can. It's important to know that when you're faced with a final restraining order, that it's not as difficult for the plaintiff to prove harassment as you may think. The third prong that the court needs to look at is an actual need to protect the victim from further harm. That's essentially the entire purpose of the New Jersey Domestic Violence Act. It's to protect victims from further domestic violence. The victim, or the plaintiff in the case, needs to show the court that they need further protection. What are some facts that bolster this prong? Well, I'll give you an example. I had a final restraining order hearing about 4 weeks ago to date. And in that final restraining order hearing, I represented the defendant. The person who filed the restraining order, they lived in Pennsylvania. The person who was on the receiving end of that restraining order lived in New Jersey. When I looked up where the person lived in Pennsylvania, in correlation to where my client lived in New Jersey, it was a 3.5-hour drive. The court took that into consideration when determining whether or not there was an actual need to protect the person from further domestic violence, because somebody who is 3.5 hours away is presumably not going to just drive 3.5 hours for no reason unless they had actual intent to harm the person. The other side of that is, if the two parties live in the same town, that's going to hurt the person on the receiving end of that restraining order. Well, they live in the same town, they're easily accessible. If there's a restraining order, it'll help prevent the victim from further domestic violence. Again, that's just a general overview of it. There are obviously a lot more facts that can kind of fit into that third prong. Just know that the plaintiff needs to show that they have an actual need for protection from further domestic violence. A couple things I want to touch on in addition to this. When somebody files a temporary restraining order, they file a complaint, and in that complaint, there are 3 important things. Number 1, it asks what the predicate act was. And there's boxes, and in those boxes is harassment, assault, terroristic threat. The officer will typically check off one or more than one of those predicate acts. Number 2, there'll be a box in the complaint that asks about the incident that led to you filing the temporary restraining order. So for example, husband and wife get into a fight at home, husband gets upset, gets a frying pan, hits the wife in the leg with it, wife calls the police. That entire incident will be written inside of the complaint. Third thing is, it's going to ask for prior history of domestic violence. This is very important because this fits back into that third prong I talked about, where the actual need to protect the victim from further domestic violence. There's a presumption in New Jersey that if you're a victim of domestic violence one time, you're most likely to be a victim of domestic violence a second, third, or fourth, or fifth time. So that's why they ask for prior incidents of domestic violence. If you're a plaintiff and you're filing a temporary restraining order, my advice to you is to be as detailed and specific as possible. Every incident of domestic violence that occurred prior to the initial incident that led you to file that complaint should be noted in graphic detail in your temporary restraining order. If you're a defendant, there's one important note that all defendants should know, and that is, when the matter proceeds to trial, the plaintiff cannot testify to anything outside of the 4 corners of that temporary restraining order. You cannot speak about any other incident that's not listed on that document. And the reason why is that the defendant needs to have the opportunity to prepare to rebut that evidence, because typically, unlike in a criminal trial, the defendant in a restraining order trial typically testifies. And if the plaintiff in a restraining order trial is testifying to information outside of what's written in the initial temporary restraining order, then the defendant does not have an opportunity to prepare to negate that information. I'm going to give you an example. Let's just say that the plaintiff starts testifying outside of what's written in the temporary restraining order, and the plaintiff says, on March 2nd, 2020, John Smith showed up at my house and threatened to kill me, okay? The defendant now shows up to court and hears that for the first time. Well, what if the defendant was in Mexico on March 2nd, 2020, and what if the defendant can show proof of that by showing his passport or by showing an itinerary showing that he was out of the country? He or she needs to have the opportunity to defend against all of the allegations listed inside of that complaint. Therefore, the plaintiff cannot testify as to anything outside of what was already reported in the initial temporary restraining order. So as a plaintiff, it's very important to be as detailed as possible when filing the temporary restraining order. And as a defendant, you need to be prepared and you need to understand exactly what the court is looking for when entering a final restraining order. When you're faced with a final restraining order, it is Jane Smith versus John Smith. It's essentially a quasi-criminal matter, meaning there's criminal implications, but it's a civil matter because it's one person against another person. We talked about predicate acts, we talked about harassment, terroristic threats, assault, simple assault. Typically, not all the time, but typically when somebody is faced with a temporary restraining order, they're also faced with a criminal charge. A criminal charge is the state versus John Smith, the state versus Jane Smith. That's when the state brings forward charges against you for the predicate act. Now that predicate act is actually in a different court. It's typically in a municipal court where the predicate act happened. For example, husband and wife, Jane Smith, John Smith. We talked about that example with the frying pan hitting Jane Smith in the leg. Let's just say they lived in Wayne, New Jersey. There would be Jane Smith versus John Smith in the Superior Court of Passaic County, where the final restraining order hearing would take place. With respect to the predicate act charge, that would be the state versus John Smith in Wayne Municipal Court. He would most likely be charged with simple assault, maybe aggravated assault. It really would depend on how bad the injuries are. But that's an important nuance, because a lot of clients that come to me, they come to me with all these paperwork and they're confused. It's very simple. One case is Jane Smith versus John Smith. That's in the Superior Court. That is a quasi-criminal matter that has criminal implications, but the standard is preponderance of evidence. State versus John Smith is the predicate act charge. That's if you're charged, like I said, with harassment, assault, simple assault, terroristic threats. That's the state versus you, where Jane Smith would be the complaining witness. Now, in that case, in a municipal court case, the state has to prove that it happened beyond a reasonable doubt. I know this sounds wild, but I've had a number of matters where my client has been charged with harassment, and at the Superior Court case where it's Jane Smith versus John Smith, they were found that the predicate act did occur, but when we go to municipal court and it goes to trial, the person is found not guilty of the charge. And that's because the standard at the criminal level is much higher. It's much higher than what's required at the civil level, which is a preponderance of evidence. The last thing I want to talk about is if you violate a final restraining order. Violating a final restraining order is a criminal matter. You will be hit with a contempt of court charge. Why? Because a final restraining order is a court order that says John Smith cannot come near Jane Smith. John Smith cannot communicate with Jane Smith. If he violates that order, he's in contempt of court. He will be charged criminally. And in that situation, you could face jail time. I will say, typically on a first offense contempt charge, depending on the facts, you will not go to jail. But if you violate it the second, third, fourth time, I will assure you, you will most likely go to jail. So if you've been faced with a temporary restraining order and a criminal charge in conjunction with the temporary restraining order, the first thing you need to do is please hire an attorney. Do not think that you can navigate a case like this without an attorney. It's very, very important to know that if you go to court on a final restraining order hearing by yourself, the judge could very well require you to proceed to trial that day. And if you're not ready, the judge is not going to care. You're going to have to proceed. So having a final restraining order on your record is terrible. It is one of the worst things somebody can go through. First things first, you will not be able to carry a firearm in New Jersey. You will not be able to carry any weapons. I've represented police officers in the state of New Jersey who were faced with a final restraining order, and the thought of them losing their right to carry a gun will result in them losing their job. If you have any job that requires you to have a weapon, well, kiss that job goodbye. Also, if you're traveling, if you're pulled over by an officer, that officer knows that someone has a final restraining order against you. So they're gonna ask you a ton of questions. If you're traveling, if you're flying, TSA knows that there's a final restraining order against this person. They can pull you to the side for questioning. Having a final restraining order is detrimental. And you need to make sure that if you're faced with a final restraining order, that you hire an attorney who knows what they're doing, who's navigated the system before, and can guide you correctly. If you like this video and you want to see more, comment down below. Otherwise, hit the like button, subscribe, and I'll see you on the next one.